Most people, when they get a letter from an attorney, they freak out and just like, oh, if I don't do this, I'll be in trouble.
Exactly. Yeah. It does stress you out,
I throw them in the trash all the time.
You're listening to the Help Me with HIPAA podcast, where HIPAA and humor collide to make learning fun. Your delightful hosts are Donna Grindle and David Sims. Relax. HIPAA help is on the way.
Welcome to the Help Me with HIPAA podcast. My name is David Sims from HIPAA for MSPs, and joining me today, as always, is my co-host, Donna Grindle of Cardin Compliance. How you doing today, Donna?
I'm great. I'm just great.
Awesome. We just got back from actually being at a conference together earlier in the week. So that was interesting. Met a lot of nice people and interesting people that we hope to be able to get on the podcast in this short future.
Yeah. I'm looking forward to it. Some great contacts and a lot of good information.
Mm-hmm. Yeah, it was. It was interesting to listen to some of the people that were speaking and some of the challenges that healthcare is having around IT.
Yeah, health IT.
Yeah. So today's topic is pretty interesting, I think. Even if I don't think it's interesting, we're going to cover it.
Great. That's a good lead in. Click.
So one of the questions that sometimes we hear and people have questions about is, can you be sued for a HIPAA violation? And so we're going to dive into that a little bit from some things that have happened recently in the news. So we're going to talk about one of those, and then we'll dive into the rest of them.
Talk about one of those and dive into the rest of them.
Yeah, talk about one of those right now. I'm trying to get you to do it one at a time, just step by step. I know you've had a rough morning and you're tired.
It's been a long week. So what we're talking about, it's not only can I be sued for a HIPAA violation, but can I go to jail for a HIPAA violation? Everybody worries about the legal ramifications one way or another. They hear about all the fines and stuff. And then, we even talked about a breach in our horror story episode where the doctor asked, am I going to go to jail for this? And there is an element in the HIPAA law itself for malicious intent, let's call it, that you can be put in prison up to 10 years and have individual fines if you are doing it with criminal intent, if you're violating HIPAA privacy laws and such. But there is no element that allows a patient to sue a business associate or covered entity under the HIPAA law. So you can't say you violated my privacy under HIPAA and I'm allowed to sue you for it. It's not there.
Mm-hmm. Which I have seen that question in forums online as well.
Right.
So there are patients that are looking for ways to leverage HIPAA to make some money.
Yeah. And, right or wrong, we're not going to go down that path about tort reform and stuff like that. But just what is happening and what can happen is our big concern in this discussion. And that is, while HIPAA law itself, and for years everybody said, the law says nothing is allowed for me to sue you under HIPAA. Now, the times they are a-changing because there are many cases that some have been ruled on and many cases still in the courts where we're starting to see HIPAA applied differently in lawsuits, and they're being applied successfully, where HIPAA is being defined not as I'm suing you under HIPAA, but I'm saying that your standard of care obligations include HIPAA. So it's a little bit of that legal rambling stuff, wrangling.
Mm-hmm.
Not rambling's what I do, wranglings. So the legal ramifications of all of this is that now there is a way around the fact that HIPAA itself doesn't include an element for civil lawsuits, but under what is known in legal terms, standard of care, that says it's, there's, again, now this gets into, we're not attorneys, right? We're doing layman discussions of very complex legal environments sometimes. That does not mean we're giving you legal advice. Listen to the very end. But the standard of care is, and we just do the simple thing and look it up on Wikipedia, which is, isn't it like known as the law of the land now? It's like the old encyclopedias.
Yeah. If it's in there, it's true.
But you can look it up online. You can look it up wherever. But it's basically saying it's the amount of prudence that a reasonable person in certain circumstances would exercise. So it's saying this is what you should be doing in your circumstance as a covered entity or business associate. Make sense?
My question would be find a reasonable person first.
Well, there you go.
I don't know any of those.
Well, there goes the show. Thanks for listening, folks. David's already blew it.
Yeah. But so once they change HIPAA and kind of add the standard of care thing to it, it really, it completely changes a lot.
Yeah, well, what they've been able to do. So there's a couple of cases, and there's several out there. So don't think that these are the only ones. But there's a couple of cases that I would kind of bring into the table for us to reference specific scenarios and how they applied HIPAA in a lawsuit. And the first one has been ruled on by the Supreme Court of the state of Connecticut. And both of these have been ruled on by the state Supreme Court. So we know where the next place is. So that's going to be interesting as we move along. But in the Connecticut case, there's an OBGYN clinic. Patient comes in, and in her records specifically states, do not allow this person to have any knowledge of my medical care. No matter what they say, no matter what they do, Bob Jones is not allowed to know anything about my care here.
So they specifically mentioned this one person.
Right. They put it in their medical records. Do not.
That's interesting.
Well, you're allowed to do that. It's one of the things within HIPAA. You're allowed to say this specific person cannot know anything. And it's up to the office to, within reason, meet those obligations. Sometimes somebody says, don't tell anybody, but I'm going to kill myself tomorrow. Don't tell anybody, I'm going to go shoot some people. Then it's a different story. Mm-hmm. But she makes it clear, and it was because this is the baby daddy, as they say, and they were in some serious litigation, and she wanted to be able to control the situation. And who knows what was going on about the whole thing. Well, what happened is the lawsuit got really nasty, and his attorney sends a summons to the doctor's office demanding the medical records be turned over for the lawsuit. Now, at this point, one would think that because your first obligation is to the patient, you would check the patient's record and see, hey, this lawsuit is from the same person that she said not to let know anything. Maybe we should ask. But
let me guess. They didn't ask.
How did you know?
And they just gave them whatever they wanted.
Yeah.
Because most people, when they get a letter from an attorney, they freak out and just like, oh, if I don't do this, I'll be in trouble.
Exactly. Yeah. It does stress you out,
I throw them in the trash all the time.
Yeah, there was another person that had the same name as me at one time that was involved with people that did illegal things, and they kept calling me demanding that I come in and tell them about the accounting practices of so-and-so and so-and-so. I'm like, look, I can't add. I can write a program to do your accounting, but I don't know anything else after that. So anyhow, needless to say, things got a little heated now because now the OBGYN doctor's office is embroiled in this whole lawsuit because they've turned over the records that she clearly did not want them to have. And off goes the whole mess, and then she sues them for libel or not libel, but for violating her privacy. Her attorney used the standard of care argument, and everybody's ruled in her favor so far that they need to be paying her a boatload of money because they did not follow their standard of care. Now, you and I both know that if we were training the people that were involved in this, they would have been terrified to violate HIPAA.
Yeah.
I love it when I leave a training class and people walk up to me and say, I am absolutely terrified now about all the data I have. And I was like, good, I've done my job. You should, that's what I want you to be. Because then you're alert. That fight or flight thing's it's fully engaged.
There's a certain amount of good paranoia.
Yeah. Don't overdo it. But so the Supreme Court, Connecticut Supreme Court said you can indeed use HIPAA as a standard of care because they argued to the Supreme Court that the jury verdict should be overturned because you can't use that as a standard of care. And the Supreme Court has said, at least in Connecticut, that is the case. So you can clearly see that while HIPAA itself was not the law that was used, it was used as a standard of care. So that's going to become a pretty interesting to see if they take it further. Who knows? Because you're getting repeated information from other court cases that basically say the same kinds of things. And in this other case, they're not even arguing whether or not HIPAA is the thing that in the Supreme Court appeal, they didn't argue that you couldn't apply HIPAA here because the case was so bad. And I have to tell you, I have read so many of these court filings and stuff, and some of them I'm like, if all of that is true, it's going to be bad because they absolutely did the wrong thing. And, in some cases I have read things where I am almost certain all of it is true because I know other things. So, but anyway, so that's the first case. And so clearly we are now being able to sue people, not necessarily for HIPAA violations, but that they didn't follow HIPAA, which is what they're obligated to do, just as a normal courtesy under the patient privilege kind of stuff, I guess is what you call it.
Yeah, the standard of care.
Yeah, well, I was trying to use something else because I'm starting to get tongue-tied over that one.
I just find it interesting that apparently the Connecticut Supreme Court must listen to our podcast and they hear the tagline at the end, which is trademarked, where we say that HIPAA is not about compliance, it's about patient care. Apparently it is.
Yeah,
now we have legal proof that we know what we're talking about.
Yeah, might want to rethink that trademark there, huh? But it is. You and I do believe it. A lot of what I do it because I believe there's a certain obligation to protect this information, and I know what's happening out there. And when you and I are trying to tell people to handle the security and the privacy and all this kind of stuff, and that's just too. And you always say, "Well,
it's not convenient.
It's not convenient. It's not convenient."
Oh my gosh, I hear that every week.
And you can't scare them with fines because they don't care. That's not going to happen to me. But everybody's dealt with some sort of lawsuit if you're in the medical world. Most anybody has, and so this is going to start also getting attention, I believe. But as we focus on this is part of patient care, hopefully we can get other people to understand that really it's not just us that seem to have that opinion. You're right. So, which brings us to the next case, which is this one is just so many things. The Indiana Court of Appeals upheld a $1.4 million verdict against Walgreens. Now, there is a woman who sued Walgreens and a pharmacist at Walgreens for negligence and professional malpractice, invasion of privacy, disclosure of private facts, invasions of privacy intrusion, all those legal terms, just boom, 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 boom. She then filed the same thing against Walgreens for not protecting her from this pharmacist because Walgreens was negligent in training, supervision, retention, and professional malpractice themselves because they didn't make this stop. And the thing is now in this one, it doesn't indicate that anything mentions privacy rules of HIPAA in here. But when I take you through it, you'll totally get how Walgreens could probably have cleared themselves or at least gotten themselves out of this mess. The pharmacist was clearly up to her elbow or eyeballs in the mess. So there's some dispute about how it all began, but so the woman who's filing the suit had a relationship with a guy. And while she was dating this guy, she used a local pharmacy, Walgreens. And over time, it comes out that she's pregnant, but they're no longer dating. And then also, he has found out that he has a STD.
I know where this is going.
So they have a baby, and he says she gave him an STD. And so, of course, they start a legal and personal battle that was very intense. You can tell if you read all the details. It wow is all I can say. I'm really glad I don't have that kind of drama in my life. So over the next little bit, she had the baby, and she gets a letter from the guy that says as it turns out, the guy was also dating the pharmacist.
Mm-hmm.
Yes. And
Okay.
so the guy who now has learned that he has STD sends notification to his sexual partners, because that's what they want you to do. And so he notifies the pharmacist, oh, by the by, I may have given you this. And
here's my prescription and
yeah, so
and my blood test.
the pharmacist now is like freaking out because I may have gotten a STD, and while she was at work one day, so she because she's turns out now married to the dude. And so she's like really trying to find out where he got this. And so she looks up the baby mamas to see if she was taking any kind of medications for STDs. Had she filled any? And was she staying on her birth control pills during the time she was dating the guy at the center of the triangle? So she looks it all up and makes sure, finds any of the information in there, then goes home and confirms how to spell her name because it's a unique name. And then she goes back to work and looks it up again because she's making sure she's looking at the right thing. And then suddenly,
Because you don't want to violate everybody's HIPAA rights, just certain people.
I just want to make sure I'm looking at the right person because I have information now. And so then out of nowhere, it's been years, like a year, and out of nowhere, the baby mama, who's just kind of going on with things, staying out of trouble, gets a text from the father saying that he had a printout showing she had not refilled her birth control prescription when they were dating. So kind of like you wanted to get pregnant on purpose kind of thing. That was scary, right? So clearly, we both know that pharmacist has done everything possible wrong under their HIPAA obligations, right? So she's in it up to her eyeballs. She did it.
Yeah.
She did it. She was wrong. What do you think Walgreens did?
I would hope they sanctioned her, and I bet you they probably made her go through some kind of training course.
They gave her a written warning and made her retake computer training. That was it. She's totally messed things up in a big, big way. And they said, naughty you, sit down and watch that video.
They should have fired her for it.
Oh, I mean, it was, that's malicious intent right there. I mean, that's right on up there. And so she goes to Walgreens, and really, lets them have it about it and finds out that, they did say she did view the prescription information without consent and it was for personal purposes. So they did confirm that. And they did confirm that it was a HIPAA privacy violation. But they could not in any way confirm that she had released the information to a third party, i.e. the baby daddy.
Mm-hmm.
And so, then she's like, this is it. And so she sues the pharmacist and Walgreens. And the pharmacist is basically like, yeah, I did it. I'm out. I don't got anything, Walgreens is the deep pocket here, but you got to wonder why they would give her so little sanction. I mean, it's really a little sanction. So this has gone all the way to the Indiana Supreme Court. And the Indiana Supreme Court says that because Walgreens, if the pharmacist had done it when she wasn't at work, like she'd somehow gone in on her off time and, remote or whatever, different ballgame, but she did it while she was at work using a Walgreens system and printer that she was authorized to use. She was authorized to do all of this stuff. So she was at work on the job using their equipment when she took the actions at issue, is what the court's saying. Mm-hmm. And because of that, she belongs to a general category of people that owe a duty of privacy protection because of what her job is. So they said they pretty much agreed with all of the lower court's rulings and said, you pay $1.4 million because there is nothing in here that seems to be wrong with any of the things you're arguing. And in this case, they didn't even try to argue that HIPAA wasn't, it would be something outside of privacy. Whereas before, that would have been included, that, you can't use HIPAA as a rule of thumb for the privacy violations and mitigate the damages. So they're not even trying it in this one. That shows you something right there. Mm-hmm. But that gets us into, again, training and sanction policies. So, they sanctioned her with a written warning, and then the training was some video training. And we've talked about, we need to do a whole episode on training programs. But I don't know about you, but I'm pretty sure
the punishment didn't fit the crime here.
We always talk about, when you punish your kids, it's kind of like, well, you wrecked the car. So I want you to watch this training video. and
watch the Fast and the Furious.
Yeah, there you go. Learn how to do this. But I mean, what do you think you would have done?
Yeah, I mean, if it had been my employee, I would have certainly fired them. I don't see how there was any other option. I don't even know. I mean, I'm sure there's some reason why they kept the employee. Maybe they were shorthanded or something. They thought they could get by with it. I don't know.
Or maybe they're just not strict about it. I don't know. But, and that's one of the things we ask people. What's your sanction policy?
Yeah. And you would think with a large organization like that, it would be a lot more cut and dry about what they would do. Mm-hmm. But
it's the thing that says they've got somebody somewhere went and there's a little matrix and they said, okay, it's the first infraction. And so on the first infraction you give, but it involved this. So, okay, written warning and this, and they don't really do anything other than that mechanical approach to it instead of really understanding the scenario.
Yeah. So maybe they went by a standard employee type policy versus, what the HIPAA sanction policy is or something. I don't know. I'm just guessing.
Well, yeah, it had to be. Who knows? I bet they're changing it.
I would imagine there's a million reasons why.
Yuck, yuck, yuck. Well, I hope they're changing it at any rate. So there's some important things to understand that, you can be sued with HIPAA as an element of it, but not under HIPAA.
Right.
Yeah. Just like anything else, we answer questions on, well, it depends how you're going to talk about it.
Yeah. And if you're listening to this a year from now, they could change it again.
I know. We don't know. We don't know what'll happen. Please make note. This is 2015, nearing the end of 2015. But one other important point to make in this discussion, beyond the fact that the lawsuits are starting to happen, is you need to keep in mind when we talk about HIPAA documentation and doing your risk analysis and doing all these other things and your training and all of that extensive documentation, that could be used. I mean, you could have that subpoenaed as part of a court case. Mm-hmm. So when they say we want to see documentation, it might not be OCR that's asking. And all these people are like, oh, they won't find me. Well, okay, wait till somebody sues you for a privacy violation and demands to see some of this stuff. It could happen. Is it happening? We don't know. We don't know what's happening behind the scenes. But my guess is, it's happening.
Mm-hmm. And it's worth also mentioning that both of these cases, we're not talking about lost or stolen laptops. We're not talking about hacking and breaching and all that stuff. We're talking about just dumb things that employees did.
Yeah. Or things that they were clearly not trained well enough to avoid, you know?
Yeah.
And the court kind of said that Walgreens really didn't do much to stop her from doing it.
Yeah.
You know, if you know, that's kind of the way that the ruling reads is, you know, you didn't really try to stop her. You just kind of said, go ahead. And then when she didn't, naughty. She didn't even get 2 whacks on the wrist, on the knuckles by the ruler. So I say they cut off a finger.
Yes. That brings us to the end of our show for today.
We're all done now.
Yeah. And as always, we thank you for listening. And if you enjoyed today's show, we ask that you go over to iTunes and leave us a review and a rating. We always appreciate that. It gives us the opportunity to let other people find the podcast and get the same value and information that you get. And also, you can share it on your social media platform of choice. You can also visit our website at helpmewithhipaa.com, and you can even leave a message or a question right there on our webpage, and we might even feature that in a future podcast. So remember, as always, and we certainly learned today, that HIPAA is not just about compliance, but it's about patient care.
You've been listening to the Help Me with HIPAA podcast, hosted by Donna Grindle and David Sims. The show created to help you with HIPAA. For more information or to ask us a question, visit our website at helpmewithhipaa.com. Neither Donna Grindle or David Sims are attorneys, and they do not offer binding legal advice concerning regulatory compliance. The information in this podcast should not be relied upon or construed as legal advice in any way. Consult your attorney for legal advice concerning compliance with HIPAA regulations.